Casey Ashmore, thanks so much for joining me. We're talking about criminal law and criminal consequences here in the great state of Texas. So, Texas, y'all, is a state that is tough on crime. It's always been that way, and it's always, in my opinion, going to be that way. Texas does not play when it comes to crime and criminal consequences. And we're going to talk about how these cases are charged and how they move through the system. And by the system, I mean the criminal justice system. And it doesn't matter what county you're in, small county, big county, the consequences are uniform. So the misdemeanor case and the felony case are charged in two different ways. So 911 call, some sort of first responder call, it's a family violence situation, it's a burglary situation, whatever it may be. First responders do their job, they respond, they come out to the scene, and they take a report, and that report gets submitted into your county or district attorney, depending on the most counties big enough now to have a district attorney and a county attorney. But that attorney, that district attorney's office, takes that police report and any other evidence gathered, which nowadays becomes quite voluminous, right? We're talking about video cameras, dash cameras, all kinds of recorded statements. Way more information is gathered now for even the smallest crimes than just a few years ago. So that information is then submitted to the district attorney's office, and through that intake system, it's either charged as a misdemeanor, which is an information, which is a discretion. You're right. The criminal district attorney's office has the discretion to charge those misdemeanors on information, which means they don't present that to a grand jury. And that information then results in a misdemeanor allegation, and then the criminal court process starts. So that process is arraignment, and an arraignment is a hearing in open court where the defendant, the person alleged to have committed the offense, comes to court. The charge is read literally from a piece of paper by the judge. Is your name X? The nature of this allegation, Mr. X, is that on the 23rd of July in the year of 2020, offense A, B, or C occurred. Do you understand the nature of that allegation? These are the judge's questions to the defendant. And how do you plead? Guilty or not guilty? This is a moment where the defendant can admit responsibility right then and there, or enter a plea of not guilty to the charge alleged and continue to work with either through counsel or sometimes by themselves, which means pro se, which means with no attorney, with no counsel. And that arraignment, there's a reason why we do that, right? Why we have a public hearing. And it's embarrassing to people to have their charge read aloud by the judge in open court. But we do that for a reason. And that's because under the empire, right, the Empire of Britain, which we broke away from, we had secret tribunals, right? And secret allegations where people didn't know what they had been charged with. They were simply arrested and then held later, right? Held indefinitely and then held for a jury trial, if they got a jury trial, at some point later. So one of the things that our justice system, it's not perfect, right? But one of the things that we did away with to make it better, to make it closer to what justice should be, is we got rid of that and have a requirement that defendants be arraigned in open court, read their charges, asked if their name's spelled correctly, and asked if they understand the nature of the allegations against them, and to enter a plea of guilty or not guilty. Right, so that's step one in the criminal process, just from the misdemeanor standpoint. And the criminal standpoint, the criminal felony standpoint procedure on that is a little bit different, and I'm going to get into that in the next video segment. Thank you so much for watching. Please like, subscribe, and share. See you on the next one in the studio on Criminal Law in Texas.